2012 gang rape case is widely associated with the Nirbhaya case that led to a lot of changes in Indian law and outrage across the country about the way our daughters are treated. But one more case had happened this same year, which was equally, if not more, horrific, where a 19-year-old girl from Delhi's Chhawla was kidnapped, gang raped, mutilated, and was attacked with acid and then left to die in an open field. Her body was found 3 days later. And now, however, instead of upholding the death penalty given to the men responsible, the Supreme Court has acquitted them, has set aside their conviction, and has set them free. We're speaking to Advocate Charu Walikhanna, who is representing the family of the victim in this case. Ma'am, this is a verdict that was not expected as such by anyone because the High Court had upheld the death penalty. The trial court had given a very serious order giving detailed discussion about the evidence. But in the Supreme Court, they have been set free. Was there any indication during the hearing that there was something wrong with the evidence?
Not at all. In fact, during the hearing, everything, even the ASG Aishwarya Bhati argued the matter very well, and we never got any indication. But definitely, because we were getting I had an apprehension that maybe the death penalty would be reduced to life imprisonment on grounds of maybe humanitarian grounds or the age of the convicts. But today I thought they would uphold the death penalty because the behavior of the convicts in Tihar has been horrible. They have been involved in drugs and all kinds of gang wars and all kinds of things, and there were lots of cases against them, which also the Supreme Court had to hear. So, I mean, when they and what was more, I would say, disconcerting for me was that it was a bench. The matter was heard by a bench headed by Justice Lalit and Ravindra Bhatt and Justice Bela Trivedi. But she authored the judgment today. Justice Lalit has not authored the judgment. She authored the judgment and she did not take even 5 seconds. She never gave any grounds. I am assuming the grounds must be she must have given a benefit of doubt to the convicts, but she just in 5 seconds she said that the High Court and the Session Court orders are set aside and they are set free. I was in shock. I could not. Had I heard it right, I had to get it reconfirmed. But
So,
that
what is the next step now? Will you be filing a review? What will we do?
absolutely immediately we'll be filing a review petition.
And has the court given any details of why they arrived at this verdict?
The court must have given details because any judgment has to have some kind of grounds for whatever. But the judgment copy is not available. The moment it comes on the internet, we'll be able to file the review.
And I will ask this again. The trial court had given a very serious order. The High Court had given a very serious order upholding the death penalty. During the arguments, was at any point of time some question raised about the role of the convicts or whether they were correctly identified, whether there was any DNA evidence? What exactly went wrong?
See, it's not in the case. There's always, when there's a police investigation, how things are in India, there's always some missing link somewhere. But you have to see it in the larger picture. The DNA evidence matched them. The disclosure, the discovery of the body 3 days later was on there. Otherwise, police would not know in the field. But yes, there were some things like whether the Delhi police, because where the murder had been, the girl's body, Chawla and Haryana are borders. So the girl's body had been found in the Haryana border. And so these are some issues, which I'm sure whether Delhi police found it first or Haryana police, there was a little bit of a grey area. But they were not enough for giving them such a benefit of doubt that they absolutely acquit them. Also, I want to say another thing. There's this whole thing about the two-finger test which has been going on. In this case, the girl, we had pointed out, in the first instance, we had pointed out that the girl's dead body, the two-finger test has been conducted in Rewari Hospital, when in the case of Lilu versus State, it has been banned. And the girl has some dignity in death. After conducting the test, the opinion of the doctor is that we are not able to come to any conclusion. Then why did you conduct that test? So it's been one humiliation after the other for the family.
Thank you very much for speaking to us, ma'am. We were just speaking to Advocate Charu Walikhanna, the counsel for the family of the Chhawla gang rape victim. The family is in shock. The lawyer is questioning why this decision was taken because the girl's body, the DNA evidence had matched the convicts. But here the Supreme Court has set them free and set aside the conviction of the men involved. The question now is, what about India's daughters? Why is it that when it comes to horrific cases like these, the legal system is always questioning the victim and not the accused? In New Delhi with cameraman Ankit Khandelwal, this is Aneesha Mathur for India Today.